Hello, everybody. It's Bree from Affordable Home Care. Welcome to this week's episode of Senior Care TV. I am super excited about our topic today because I feel that it's very important for anybody to know the information that we're going to discuss, whether or not you're caring for an elderly loved one, you're in the senior industry, or just for yourself to have in the future. I think everybody can benefit from having this information. We're going to discuss estate sales and what goes into it. And I'm so lucky to have my guest today. His name is David Ingber, and he is an attorney for ELLIAS Elias, a law firm located in West Bloomfield. So I'm going to kind of let him do his intro, and then I'm going to just ask a couple questions, and we're going to fire away from there. So go ahead, David. Nice to have you.
Hi, Bree. Yep, thanks for having me. Again, my name is David Ingber. I'm with ELLIAS Elias, where we're a small boutique law firm located in West Bloomfield, Michigan, where we do estate planning work and business planning work for people. And, I'm happy to be here today and explain estate planning. Do you have any early questions before I begin?
I do. So should everybody have an estate plan, David?
Yes, you should definitely have an estate plan. If you do not have an estate plan, then the state of Michigan will provide you with a default estate plan for you. Wow. Now that's important because your assets may not be going to who you want them to go to. It's going to go under what the state thinks is the best plan for your assets. So it's highly recommended that everybody should have an estate plan, no matter how big or how small your estate plan is. A lot of people I find think that, well, I really don't have that much. I just want it all to go to my family. They can just deal with it at the time of death. Well, it doesn't work that way, because under the state of Michigan, if you don't have an estate plan, you're under the rules of intestacy. And under the rules of intestacy, the state determines who gets your assets. So your assets may not go to where you want them to go to. And there may be certain situations in your family where you want certain things to go to certain people. There may be some special needs, planning that needs to get done. And so it's important for you to have an estate plan, no matter how big or how small your estate is.
Wow. I mean, that's very unsettling to know that your assets can essentially be, dispersed anywhere. So, wow. Okay. I know I've been procrastinating it myself. So definitely something I need to, get on the calendar and just.
Yeah, we can definitely help you with that, Bree.
So what's included in an estate plan?
So in an estate plan, you would get a will, a revocable living trust, a certification of trust, a durable power of attorney, a medical power of attorney, and a personal property memorandum. And I'll go over what all of those documents do. So the will is what most people think of as part of their estate plan. The will says where your assets are going. Now, in the situation with us, we would provide you with a will, and the will would say that you're leaving everything in trust through your revocable living trust. So the revocable living trust is going to be the document that's going to determine where your assets are going to and who's going to be the successor trustees upon your demise. Then we also provide what's called a certification of trust, and that's an important document because that document is used to help to title the assets. So what you need to do is, once the estate plan is set up, you need to then fund the trust. And so we do certificate of trust, which you can hand to the bank or to other brokerage accounts and get those transferred into the name of the trust. The durable power of attorney allows somebody to act, and the durable power of attorney can either be effective upon your incapacity, or it can be effective immediately. So you have to decide whether or not you want somebody to have immediate powers and able to do things for you, if you want it only to be effective upon your incapacity, or if it's going to be effective immediately. We also prepare a medical power of attorney, which allows someone to make medical decisions on your behalf should you become unable to make a medical decision. And what you want to do in that is explain to that person who you selected what you want to have happen. So you should have a discussion with them as to what you would want to have happen if, God forbid, there's a medical emergency and you can't make a decision, what kind of treatment you would want and how far they should go with seeking treatment for you.
Wow. I mean, that's so important for me to know this because so many of my clients and their families ask me these questions all the time and I just don't have the answer for them.
Yeah. It's very important to have these documents ready to go because you never know what's going to happen. In this way, you're ready to go. And it provides peace of mind for people. And so it's very important. And it's a very easy process to do. It's just in terms of you meet with the client and you discuss, what are their assets? How are they titled? Is it a husband and wife? Are the assets titled jointly? Are they titled in in the husband's name, or are they titled in the wife's name? Are they titled, some people have a bank account and they may have the child on the account with them to help pay the bills, and to write checks. And in that situation, is the child a signer on that account, or are they, a title holder? And we have these discussions and figure out how things are done. And then we discuss with the client what they want to have happen with their assets. Yeah. Is there a specific situation where they maybe have a special needs child, and so they need to do some planning for that? We can help with that. You may have a situation where they want everything to go to their kids equally, but there may be some family dynamics where one of their children is super successful and they don't really need assets from the parent, and maybe one of their children needs a little bit more help. There's some special circumstances there. And so maybe you want to, give everything to that child. And when I say you're going to give it to that child, maybe you may not want them to get it all at once. You may want to have it be in trust for that child. So for instance, maybe at age 25, they can get a third of what's in there. Or at age 30, they can get, half of what's left. And then at age 35 or 40, they can get the balance. So that's the advantage to having a trust. Everything's laid out as to how the assets are to go, and the advantage to keeping it in a trust as opposed to just doing it in the will. The will has to go through probate. Probate's an expensive situation. It's costly, it's timely, and more importantly, it's open to the public. Anyone can see, can go to the probate court and get copies of documents, and it's all open for public inspection. A trust administration is private, so nobody would know where your assets are going, who's going to be the successor trustees, and when they're going to be getting assets. And so that's a very important aspect to estate planning, is to try to have everything in the name of the trust.
That's huge too. And I, like you had said, peace of mind, I think that nailed it. I think peace of mind is priceless. So, and knowing that you have all these affairs in order, I think, lets people rest a bit easier too. So, wow. And the privacy part, I didn't know that if it wasn't in a trust. So that's major, because you don't want everybody knowing your business. I mean, it's your personal business. Yeah.
Most people do not like to have all of their, especially, they just don't want everything out for everyone to know. It's private information as to what their assets are, who they're going to, and when they're going to be distributed. And so if you do it through the Revocable Living Trust, it's all private. There is trust administration that gets done, but it's not open to public inspection. There's no court supervision on that. Whereas probate is public. It's through the probate court, and so that's more open to inspection. And another important thing to remember with an estate plan is it's all changeable. So as long as you're alive and you have capacity, you can make whatever changes you want to your estate plan. So for instance, if everything's going well with the family, you're getting along with all your kids, and you want everything to be done equally, that's fine. 2 years, 3 years down the road, there's a circumstance going on where maybe a child's going through a divorce, and so you don't want them to get all their money up front. You can make changes to your estate plan, and you can change when those assets are going to be distributed and what they're going to get. And maybe you want to hold some back. You want to change who you selected to be trustee. You want to change who you selected to be on durable power of attorney. Those can all be changed. This is not irrevocable. So even though you're doing this document now, you're setting up the estate plan now, things can be changed. It's a fluid document. Nothing is set in stone until you've passed away and you don't have capacity. But until then, you can make changes whenever you want. So if on day one you want it to go this way, but a year or two down the road, you decide, you know what, things have changed. There's been a change in the family. I don't want this person to be the trustee, to be helping you administer my estate. I want this other person. You can go ahead and make those changes. So it's very important to remember that all this it's important to have the estate plan set up, but it's important also to review it every year just to make sure it's still comporting with your wishes. Because the last thing you want to do is have set up an estate plan on day one and said, okay, this is how I want things to go. And then a year or two later, there's a change in the family dynamics, or there's a change, you've inherited a whole bunch of money, or you've spent money, living. And so there's less to go around. And so maybe you were making a whole bunch of gifts before and you want to cut that back. All these things can be changed.
And that's so reassuring, because what we all know in this past year has proven that anything can change in the blink of an eye. So, that's very, I'm sure, a reassuring feeling for people to know that they can continue to update this and keep track and make changes as time goes along and things change. So what's the process? What are the important steps to preparing an estate plan?
All right. So the initial thing is for the client to gather a list of their assets. And that would be, do they own real estate? Do they have a business interest? Do they have brokerage accounts, bank accounts? Are they involved in any other investments? Stuff like that. What are their major liabilities? So they want to get a list of their assets and how those assets are titled. Are they titled jointly? Are they titled in just their name alone? And then from there, we want to have a meeting. Due to COVID and what's going on now, we can do it via Zoom right now and just have an informal talk with people and, get a list of their assets. And then we want to discuss who they want to have to be administering their estate. So who they want to have to be the successor trustee when they can no longer act. And they should have, I recommend having 3 to 4 people as backup, so maybe they want one of their kids, or they want their accountant, they want their attorney, have somebody who can administer the estate for them when they're no longer. You also want to discuss who they want to have selected for durable power of attorney. Do they want to have, a family member or somebody else? You want to select also who they want to have for their medical power of attorney, who's going to make the medical decisions on their behalf. Then after we discuss those issues and they've come to some determination as to who they want and how they want their assets to go, we then I then prepare the estate plan for them, draft the documents together. We can have another meeting to go over the documents and discuss those. We can do those via Zoom, where I can email draft documents to them. And once the client has agreed, that they're fine with how the documents are, we set up a time for them to come into the office and then to have things witnessed and notarized. Unfortunately for that, they would need to come in. There is some ability to do remote notarization, but that's more of a hassling process. And so if they could just come in for just a quick time to just sign the documents, it's under an hour, because they've already reviewed all the documents ahead of time. So there really shouldn't be any changes that will be made. Mm-hmm. And they just come in. I have the witness and notaries already here for them. We get everything signed up. The clients then leave. Then what I do is I prepare a closing package for them, give them a summary letter, an instruction letter on how to fund the trust, and also give them a summary letter explaining, what's in their estate plan documents, and they have the originals and they're good to go. And then every year or so, they should be reviewing those documents.
Yeah. So you mentioned funding. So why is funding important?
So funding is important because you want to make sure that to avoid probate. The whole goal of setting up this estate plan is to avoid probate costs and expense and delay and things not being private. So you can set up this whole trust, but then you have to get it funded. So if you have things that are just in your name individually, you need to get it. You need to go to the bank. If it's a bank account, you need to go to the bank and have them retitle in the name of the revocable living trust. It's no big deal. You still have complete control over the trust. So it's not like you're giving up anything. You're just transferring the name from your name individually into the name of your revocable living trust. Because things that are in your name individually are subject to probate. Gotcha. But if it's in the name of your trust, then it's not subject to probate.
Okay. Wow. Okay. And then I just have one more question for you, and this is such great information. So what's the most important aspect of estate planning? What should we know?
So the most important thing to remember is that this is fully changeable. It's a fluid situation. You can make whatever changes you want to the documents. So for instance, if one day you decide, you want your Aunt Sally to be the personal rep, and unfortunately she's passed away, since the document is signed, you can then select, backups. If there's a change in family dynamics, you need to make a change to the document, that can all be done. So, just because you've got the estate plan done doesn't mean that things can't be changed or undone. Whatever you want to have happen can happen. That's the important thing to remember. It's you're the one who's deciding where you want your assets to go. And if you want to make a change later on as to where things are going, you can do that. It's your asset. You can make whatever changes you want.
Yes. Well, thank you so much. I mean, like I had mentioned, I think this is kind of a scary thing for people to deal with if they don't know anything about it, and you definitely have made it seem a lot less intimidating. And I mean, it's quite simple, to be honest, if you just meet with the right
it's not an intimidating process at all. It's nothing to be scared of or anything like that. You're just telling me where you want your assets to go, and we go ahead and do that for you.
Thank you so much for meeting with me today. David, would you mind just providing your contact info so if anybody has any questions, they can reach out to you?
Absolutely. Yep. The best way to get a hold of me, you can reach me on my office phone, which is 248-865-8400, extension 105, or you can send me an email. The email is djingber@e and then the number 3pc.net.
Anytime I have clients asking me these questions, he's the guy that I go to. So, because I definitely don't know the answers. So,
thanks, Bri. I appreciate that.
Yes, of course. So thanks everybody for tuning in, and I look forward to talking to you all again next week. Bye, everybody.